For the third time in 4 years, Governor Hochul wants to roll back parts of the 2019 criminal justice reforms. This time she wants to amend the discovery process that requires prosecutors to share evidence with criminal defendants in a timely fashion. Before the reforms, defense attorneys sometimes didn't see the evidence against their clients until the last minute, sometimes even the day of the trial. The governor says the changes went too far back in 2019, and it made it easier to dismiss cases and allow criminals back on the street. So, Sarah, is Governor Hochul right that the discovery process should be changed again?
You know, I haven't seen convincing evidence that that this 5-year-old policy warrants any kind of rollback. It seems to me that she's being driven more by political concerns than by a careful analysis of the policy. So she sees the winds shifting a bit, so that she's afraid that she'll be targeted as soft on crime. And so she's trying to undo some of what I think are very reasonable criminal justice reforms. It seems like in the lead up to this, she only consulted with prosecutors, not with defense attorneys and with law professors who are supportive of these changes. So I'm just not, think her motives are not very good, and so I sort of distrust the conclusions as well. I think that these are very reasonable responses. And, you know, in general, what we can say is that prosecutors tend to have a lot of advantages in our criminal justice system. They have more resources, they have ties with law enforcement, they have more information typically, and so they're better positioned, right? And what they seem to have been doing is often waiting till the very last minute to share really critical information with the defense team, information that would have allowed defendants to put up a better case for themselves, maybe plea with from a position of more power.
And Michael?
Well, I think we have to consider the idea, to Sarah's point, that the governor is up for re-election soon. So I'm not sure if this is a play for the center or a play for the soft right, or if she thinks she's playing three-dimensional chess, I'm not sure. But anytime an accused person's defense team is granted more time with evidence, in my view, it enhances the idea of due process. I'm going to repeat that. Anytime a defense team has more time with the evidence, I often have thought that it enhances the idea of due process in the 14th Amendment, which I think is a good thing. And I also think that the NAACP Legal Defense Fund and Project Innocence would also agree with that. So I hope the governor rethinks this activity on the discovery process very soon.
Okay, and I mean, is there if the defense lawyers are getting this information, the evidence, well in advance, I wonder, is there any danger, you know, inherent danger then to witnesses who may be called on in a trial? I think that was one of the original reasons for having the system set up the way it was initially. Tara?
I think I think we need to be honest and say there can be, but from what I've been able to find, that the problem for witnesses is most common in, for example, domestic violence cases, for example. That's a place where there have been some problems. And so part of the issue, and Sarah alluded to this, is the fact that since the governor seems to have only worked with prosecutors, not with defense attorneys, you know, this might have been a case where maybe there could have been a tweak that would have addressed that issue, especially in the case of domestic violence, without going to the extreme that the governor has gone to, where she really, in a sense, is trying to roll back some of the reforms that occurred 5 years ago. But, you know, I think there's always a danger, sadly, for witnesses in cases. And that's just, unfortunately, the reality of our criminal justice system. So I don't think there's been enough evidence that witnesses are in danger to have really gone to the extreme that the governor does in her proposal.
Now, prosecutors say that, you just referred to them as extreme, you know, she's Hochul going to the extreme, but prosecutors, Michael, say that these are minor changes.
Minor changes from their perspective. If I were a prosecutor, I wouldn't want the other side to have any sort of equitable, egalitarian time either if I were a prosecutor. So I think that's an expected response from any prosecutor because it's to their advantage.
Mm-hmm. And the idea that, Sarah, that prosecutors often would not turn over, and they had the legal right prior to 2019, turn over evidence until very late in the game. So what's the impact of that?
Well, it means that people who might be innocent of charges, or we might see them as sort of less guilty, right, do not have the information needed to plea out on better terms, right? And so, I mean, this speaks to a kind of, not all of these people are in jail or accused of felonies, right? Our system takes in a lot of people through our misdemeanor system. And misdemeanors vary, but some of them are for really petty things like shoplifting or writing a bad check. And what happens is they get scooped up into our criminal justice system, often thrown in jail if they can't pay the bail and the fines and fees, which are going up associated with this. They have to spend their time in jail up to their trial date. And so this need for speedy trials is really important for these people. And again, sometimes they're innocent or accused of very minor things. I mean, this whole law was written partly as a response to Caliph Browder, who was found guilty of stealing a backpack and spent 3 years in Rikers prison. He later, unfortunately, took his life because of that experience.